Everyone. Welcome to our 15th episode. Today we have our second international guest, Nicola Canestrini, Italian and international and European criminal lawyer. Uh, so it's a pleasure to have you here, Nicola. So
Thanks, thanks for inviting me.
it's going to be a very interesting conversation for sure. So let's go straight to the point. Uh, you have this phrase on your website that the reason that why you are a criminal lawyer is I love being a criminal lawyer, criminal attorney because I love the adrenaline rush of court hearings when I fight for fundamental rights and equality before law for everybody. When did you understand and had this desire to fight for fundamental rights?
It's like a family thing because I'm the fourth in a row of criminal defense attorney here in the northern part of Italy. So even if I tried when I came out of my law school to join a commercial law firm in Milan, where we were working, they were working, I was just a junior on international mergers and acquisitions and intellectual property and things like that. I couldn't get used to the fact that an attorney wouldn't wear a robe and wouldn't appear in court and was only handling agreements, and of course lot of money was involved, but it wasn't really my thing. So I thought back to my father, who was a very active, politically active person after the Second World War. He was a partisan, joined the Communist Party, and I thought that society, that I felt like morally obliged to give back to society something that I had the opportunity and the luck to have had without really deserving it, because I could study. I didn't need to go to work immediately after after school. So I felt that solidarity should be something more real, that not something just written in the books. So I decided to pick up my father's step and join this small law firm. Back then, it were only three attorneys in the northern part of Italy, in Rovereto, near to the Garda Lake. And then I started to enjoy going to court, and there enjoying the most fundamental freedom and the best part of our job as criminal defense attorney, which is exactly the freedom to do and to say and to defend whoever we want, however we want, with no responsibility other than not towards our client or clients and towards ourselves. So that's why I joined, and there I saw that our criminal justice system, and I think I'm not speaking only about the Italian one, is weak with the powerful and powerful with the weak. And I thought that this could not be right, because justice and laws and rights are things that are mostly needed by the weak, not by the powerful. Because the powerful, they do their justice themselves. They just send their people to force others to do what they want. It's the poor, it's the disadvantaged, it's the vulnerable person who need rights and attorneys.
Okay. So I think that's the course of every law student, or mostly that we join law school to more to follow and change the world and make the world a better place while defending the damned and the people that don't have money. But then I think most get stuck on that commercial route because you go to a big law firm and you see the money, you see the different lifestyle, and you forget a bit of uh, yeah, the reason why. So so your law firm is as 150 years. It's,
Yes,
it's 150 years old. Okay, that's
yes, over 150, because it was founded in 1870, when the city I'm living in, so it's Rovereto, was still part of the Austrian Empire, which is a little bit crazy thinking about it right now. My ancestors defended smugglers of salt and tobacco between the reign of Italy and the Austrian Empire, because it was on the borders, of course. So there was an international dimension as well, I would say, even if, of course, then the international dimension grew when I started to connect to other lawyers, to feel that international criminal cooperation could be a very interesting field in which we could practice. And I think you are aware of that. The most valuable thing in working in this area is that courts still still need to decide how they could solve problems. So there is not a super settled case law. You can ask the Court of Justice to intervene, to clarify. There are a lot of issues still to be resolved, and there you have the idea that that your work as criminal defense attorney still counts. And if you have ever had the luck, as I did, to go to the European Court of Justice in Luxembourg in discussing before the Grand Chamber an important issue regarding fundamental right, I think that this is the most satisfying experience that you could have as a criminal defense attorney.
So, so that's why, because distinctly from your ancestors, like, and because also the world is a bit different now, you are not only a national criminal lawyer, but also international. So, why the need for going more abroad, let's say?
But it was a little bit out of luck, as it happens. So I've ever been, as you mentioned, as a student, everybody of us was thinking about being active even on an international in international environment. And then I started to teach at the University of Ferrara the laws of armed conflicts. Sadly, I may add, because what we are experiencing in Europe and in the war between Israel and Palestine and the other Arab states is really something that should worry us more than our public opinions do right now. So after being involved at the university in teaching international law, a case came up to my attention which involved an alleged corruption against the lady, my client. She was in prison, and so I picked up the chance to become more and more active in that field, extradition, and then later, a decade later, in European arrest warrants. And as I told you, that's very challenging. And I even had the luck to meet and become a friend of a lot of other defense attorneys all around the world. And so we formed a quite unified group. And in Portugal, you are really lucky right now because the president of the European Criminal Bar Association is Vania Costa Ramos.
We had her on our podcast. Like, she was our like third guest when we started before becoming. So it's.
So, and I may add, I didn't know that, but I'm super glad and super honored to be in the same podcast as she was, because I think she is really one of the best, if not the best, criminal defense attorney acting in international criminal cooperation. So,
we stopped listening, Nicola. We stopped listening. 1 second. Your audio went off. Yeah, your audio went off for a second.
So, okay, I'm sorry for that. Being among friends, helps us when the client is not really capable to pay. For example, you can get back to them and ask them for favors, as we criminal defense attorneys do, because people, they say that we are interested only in money, and it's true. We need to live, we need to have our income. Even if we love our jobs, we need to be paid. But there are cases, a lot of cases, in which we do our job out of the feeling that we need to ensure people fundamental rights, even if it's completely an unpaid job.
Yeah. Going just back
You,
to just
before regarding this, I know I saw in your website that you've participated in some pro bono activities. Could you describe more in depth those initiatives?
I think our common feeling is that we need to act in a very specific and real, in the real world, for ensuring rights. And this is not only in the courtroom, right? So we need to help people to uphold rule of law, especially in tough times in which we are living in right now, in which it seems that security is the only issue, that rights don't count, and in which we may, somebody may tries to convince us that what counts is just money, power, and freedom over solidarity. So we need, and I think it's a common value, we need to act even in the society. For example, I am engaged in many projects for endangered lawyers, for example, but trials observation as well. My last mission was to Ukraine when the war was already in place. And I went there as an international trial observer in trying to express solidarity to a conscientious objector who refused to go to war. He was ready to serve his country, but he didn't want to kill anybody. And since the conscientious objector, as you may remember, is a fundamental right protected by Article 8 of the European Convention of Human Rights, I thought it was our job to go there and to tell him that he's not alone in his fight, and to tell the court that the international community is watching what is happening and how, especially in tough times, they were ensuring fundamental rights to everybody. And I have to admit, for example, that the help and the organization provided by the Ukrainian National Bar Association was really surprising to me, because even if it was a sensitive case, of course, we're speaking about a country who was invaded and who was very concentrated in fighting against the enemy. They were able to understand that the rights are important in times of war as well. So I would even add that rights are more important in exceptional times, because what constitutions and fundamental rights do is they help us to remain focused on the important things, even when it seems that everything is different, and there is an exception, and there is a emergency. In that times, exactly, we need to uphold our rights, because if we introduce an exception to fundamental rights, they wouldn't be fundamental anymore. They would be just, let's say, a favor given to us by authorities. But this is not the right way to think about. And of course, I'm enacted in many pro bono initiatives in granting poor and disadvantages their rights, even if they don't have the money to pay their attorneys.
We also saw that you drafted as a member of the ECBA, Human Rights Committee, you drafted amicus curiae brief for the exclusion of torture, tainted confession of Abdel al-Rahim al-Nashiri, Guantanamo detainee. Did you go there to the Guantanamo Bay, Guantanamo prison, or and how was the
No,
experience itself?
No, the experience. We were asked by the defense attorneys of the defendant to sustain as an amicus curiae. So ECBA was asked by the defense attorneys to sustain with an amicus curiae a fundamental principles that torture-tainted evidence cannot be used in any case before any court, and here it's full stop. There were times in which confession were extorted by torture, and tortured people, witches, confessed to have sexual behaviors with the devil. So the tortures do not lead to the truth. They just lead to an immense suffering, which makes people confess whatever they believe could stop their pain. And Guantanamo and all what happened with those so-called enhanced interrogation techniques, which were widely used by the US against their enemies, was another very dark side of our common history, because we had at that time President Trump, now President-elected Trump, who openly spoke about the fact that torture works. And he's wrong, because torture does not work. And this was established regarding Guantanamo by the US Senate. And in that case, the commission, the report is public available, by the way, but the commission established that there wasn't one single case in which the torture led to real evidence of other terrorist organization cases in which something could be cleared or avoided. So having those enhanced techniques happen was really a shame for our society. And we felt, as European lawyers, criminal defense attorneys, that we needed to support who is fighting before US courts, which are military courts, who wanted to use torture-tainted evidence. By the way, what we were drafting was an argument against the appeal brought in against the decision of a US first instance military court who excluded that torture-tainted evidence. So I think that this is one of the most important jobs for us, to step up to defend people who nobody wants to defend, to go to places where nobody wants to go, and to say things that nobody wants to hear, because that's the job of a criminal defense attorney. We don't need to look for sympathy of public opinion, courts, or public authorities. That's not our job. You may have heard of Clarence Darrow, who was a US criminal defense attorney, who said exactly that as a criminal defense attorney, you need to be tough because nobody loves who defends the hatred and despised.
Yeah, yeah, 100%. And going back to the international cooperation between lawyers, I'm interested to know if, for example, if you recently, because of what's happening in Palestine specifically, and we are going to have in a few weeks, hopefully, we'll have a international criminal law professor to go through all the premises of genocide and all the war crimes and everything in the Statute of Rome to try to put it in like on everybody's mind what's happening. But I wanted to understand like if you have any contacts and cooperation with like Palestinian lawyers, if that's a thing, if there are organizations regarding, for example, the administrative prisons detentions that happen, for example, in Israel, Palestine, of people.
No, not yet. Even if one of the projects that we have is to organize a visit in order to make a fact-finding assessment to see and to collect witness statements for our colleagues from both sides, because we are speaking to criminal defense attorneys
Of course.
on place, and I'm sure that gathering evidence from both sides would be helpful, because we know how it is, because it's our job. There is not one truth. There are many points of views, and it's only in the, let's say, cross-examination, if we were in court, that sufficient argument come up in order to allow us to make our own opinion. Even if I need to add, of course, that we may expect from terrorist organizations to act in a behavior which is unacceptable under international human rights law. So that it has to be said very clearly that what happened on October 7th was a dramatic moment for everybody of us, and which has no excuses, and is and should be treated like a very serious crime. What we could expect, that what I couldn't expect, is that the state could act like a terrorist organization. Because if you bomb schools, hospitals, even if you have evidence, let's say it like that, even if you know that in the basement there are terrorists who are hiding, bombing a school or hospital is an international crime. It is how it is.
Exactly.
So,
It's still an international crime, even if you have evidence of yeah.
exactly. So let's say it's not even if you think that there could be, but even if you are sure, but and we know that because that's exactly what laws are for. They are there to protect us from giving, from doing in our rage whatever we feel could be done in order to take revenge, to seek justice, call it how you want. But that laws should be binding even in very exceptional situation, as we mentioned before. And we know how it is because we had this when we were back law students in law school, isn't it? So there is one terrorist in an airplane, and the airplane is directing to in order to make a school explode. Could you take the airplane down, killing the terrorists, saving the school, but killing even innocent people? We know how many questions this could raise, but still the answer is, if we renounce to our fundamental principle, the terrorists won. It's so easy. And it was the Israeli Supreme Court who told us that, because they stated 20 years ago, I remember, I repeat, it was the Israeli Supreme Court, that sometimes democracies have to fight with a hand on their back, because we cannot use same means as terrorists do, because that's exactly the things that makes the difference between them and us. And I hope that international public opinion, Israeli public opinion are going to teach those among the in the government who don't want to recognize that there is this fundamental principle between civilization and terrorism. I hope that they will think about that and reconsider what they are doing, because this put them, sadly, once again on the wrong side of the story.
Unfortunately, I'm not that hopeful, at least in this moment, and with the Israeli government acting as it has been acting. But let's see, and let's see what the international community will do and how it will act and how is it acting, because it's also a bit, at least in my opinion, not acting, not doing enough to stop all the war crimes that we are watching daily on a daily basis, and we are getting used to it. But for this matter, we'll go. It's a complicated matter, and we could stay hours talking about it. So,
Yes, but let me add something, if I may.
of course.
You may know the story of the hummingbird. It's an African tale in which that's the story. One day, a terrible fire broke out in a forest, and there was this raging wildfire, and frightened, all the animals fled their homes and ran out of the forest. And then they stopped to watch the fire, and they were feeling very discouraged and powerless. Everyone thought elephants, the king of the forest, so lion, big animals. They thought there was nothing they could do about the fire. The only one who was acting differently was a little hummingbird. And the hummingbird decided it would do something. So it swooped into the stream and into a river and picked up few drops of water and went into the forest and put them on the fire. Then it went back to the stream and did it again, and it kept going back again and again. And all the other animals, they watched in disbelief, and some tried to laugh at the hummingbird, discouraging it, saying, it's too much fire, you're too little, your wings will burn, your beak is too tiny, it's only a drop. What do you think you could do to stop a so big fire? And the hummingbird, when it was confronted with this, the hummingbird looked at them saying, I'm doing what I can. And I think that everybody of us would do what we could in that situation. Our many drops of water, they will form a flow, and we can stop this fire, and we don't have an alternative to that. So it's an everyday practice of our little drop of water, hoping that bringing it to, if we are on our own or if we are very few, the fire won't stop never. But if we are join our forces, we will be able to stop this fire.
I think that's the motto of the criminal lawyer, because
exactly.
that's
A nice metaphor.
that's that's like the perfect motto. Uh, uh, and we saw, going back to international cooperation and international. I know we are short on time, but we saw that you wrote a paper regarding Interpol Red Notice abuses and how it's misused by states in order to attack dissidents, political dissidents, journalists, and so on. Vixen.
Can you hear me?
And regarding this, before going through it, can you first make the distinction on what are the Interpol red notes and international arrest warrant?
Yes, so there is no international arrest warrant. The arrest, except those issued by the ICC, so International Criminal Court. But usually, international criminal cooperation, we are speaking about national arrest warrants, who are put in the system of the Interpol. What is an Interpol? Interpol is a police cooperation agreement of 90 years ago, of 70 years ago, sorry, in which most of existing countries try to join, because it is police cooperation is a fundamental issue in order to uphold rule of law. Because of course, so criminal justice needs to be able to go over the borders as criminals or suspects do. So we are all aware of the importance of international criminal cooperation. So that's why Interpol exists. That's why it is founded with a huge amount of money. We're speaking about really millions and millions every year going in from member states to the organization in order to uphold the rule of law. So Interpol has many, many notices, but the most known are the red notices, which is request for location and arrest of a wanted person with a view to extradition. It's different how Interpol red notices are treated in their countries. In Italy, for example, an Interpol red notice leads immediately and automatically to a provisional arrest by the police. And then the court has to validate the arrest and to decide for a national arrest warrant again, which is a extraditional pretrial detention order.
But that's a bit,
So red notice.
Nicola, but in what you just said, like the automatization of it can lead off like the underlying charges of the arrest of the notice, they can be totally biased. And if it's automatic, if there is no if the police and the public if they don't analyze the charges and understand if that's applicable, if that's if that's
you're right. Interpol is vulnerable to be abused by member states, which may use and have used in the past its system as a mechanism of targeting legitimate activists, journalists, political opponents, criminal defense attorneys, and so on. And this, which is a well-known problem, and the problem is known as the so-called Interpol abuse, has led to important decisions, even by Interpol, who now has enacted a kind of commission. So it is a commission which is called CCF, Commission for the Control of File of the Interpol, which tries to filter the abusive red notices. Fact is that red notices are thousands and thousands, and the commission is quite understaffed, but it's still a good start, let's say it like that. You see, Interpol cannot be used as a tool against political opponents, and is obliged, if you read Article 2 of the Interpol's constitution, the organization has the mandate to ensure and promote international police cooperation in the spirit of Universal Declaration of Human Rights. So if you allow Interpol to act against that spirit, it is putting in great danger same cooperation, because who wants to be a tool for undemocratic, not liberal, fascist regimes all over the world? So in that regard, we as criminal defense attorneys are on the front line of this fight, in order to ask Lyon, the headquarters of Interpol, to verify the legitimacy of some red notices, which have very big consequences, worse than not the national pretrial detention order, because the national pretrial and detention order can be challenged, but Interpol police organization has not the safeguards that it should have. And so, of course, it would be our duty to recognize and to step up for the violated rights that may come to us while we are doing our job.
Nicola, we have two more questions, and we'll let you go. Sorry. And we also read alternatively of the red notices, Interpol red notices, and in an open letter that was written by 24 lawyers, you included that Turkey, in order to avoid all the media attention of the red notices abuse, has been misusing of Interpol stolen and lost travel documents, SLTD, by improperly recording as loss of stolen or revoked or invalid the passport of dissidents, political dissidents, in order to have them deported to Turkey. This open letter was written like a few years back. Was there any advance on the Interpol way to approach this matter, or we still see this happening on a daily basis? Daily basis.
It is still happening. There are some contacts because, of course, we cannot make general statements. So there are some jurists, even in the Interpol organization, who are aware of the problem and that the risk that Interpol becomes a tool for, in this case, Turkey. But it's easy to speak about Turkey, even if I have to remember that the world was watching silently during when after the Jazzy Park demonstrations, even criminal defense attorneys were arrested in court, in plain court, and put in jail. So the world wasn't interested when criminal defense attorneys were targeted, and it was a big mistake, because when you target the watchdog of rights as journalists, attorneys, and other important figures in democracy, it's only the first step. Then the reaction to the attempted coup d'etat was recognized by the whole world, and now the whole world knows that even if they need Turkey because they are needed to avoid migrants to flow all over Europe and to invade our countries and to destroy European civilization, how they put it, and I don't know if those people know that that Europe has been invaded by migrants thousands of years ago, coming exactly from Africa, and I don't know if those people are aware about the fact that migration is the thing that always happened and hopefully always be happened, and it doesn't matter how difficult it will become if you don't create safe roads. People, they will always leave their home countries when they are starved to death, when there are wars or other push factors, because we shouldn't reason about the pull factors like somebody does, saying that NGOs, they are pulling out people from their homes as if it was enough for somebody who was living in his home to leave it
all behind because they want to. And that's that's the rhetoric. They just leave everything. They abandon everything just because they want to come to Europe and enjoy our country.
I don't know exactly what. Probably coming here and being abused by our citizens who are really grateful to the government that they can hire people without proper guarantees, with proper
exploited,
exploited and whatever. So I don't know exactly how those politicians think that they act. But I'm sorry, I'm a little bit far too going into politic details here. So those people enjoy fundamental rights as everybody. That's the point. And no matter what you do, solidarity is a fundamental, not right, but it's a fundamental duty. So you cannot let people die because you think they should avoid coming to Europe. I can accept that governments, they have the right to then decide what to do. People in Italy, you have this big problem with administrative detention center with migrants, and
in Albania.
In Albania, but not only, so to deport them. And they are, our legislator is ignoring European Union law, ignoring the decision of Court of Justice, who was of the 4th of October of this year. So it was not very difficult to find that you cannot define a safe country when there are parts of its territory which are not safe. So that's the issue here. But we are still putting in jail people who didn't commit any crime. So administrative detention centers are even worse than jails because the lawyers are not admitted. It's very difficult to get people to claim their rights. At least in prisons, there is a system who should at least try to avoid abuses to detainees, and the so-called CPRs, so administrative detention centers in Italy, are black holes in our, even under our rule of law.
And it's perfect that you mentioned that, because we saw that you represented the Iuventa crew and had a successful outcome. The NGO that rescued immigrants that were drowning and trying to come to Europe and mostly Italy in that zone. How was that experience like in terms of the social part, the political side also? Because I imagine that you've been attacked, because in Italy, as most people know, or if they don't, they will know now. There's like at least the government is very, as it's a far right government, it's very opposed to migration, and there is a discourse against migration very strong, and against the boats coming and what has to be done. So, Nicola.
First of all, I would like to mention Miguel, who was a Portuguese member of the Iuventa crew, and it's due to him and to Vanya that I have been involved in this trial, because the Italian judicial authority issued a European investigation order against Miguel, and he went to Vanya, who asked me in summer of 2019, I think, oh, there is a case in Sicily, are you interested in that? And I said, what are you talking about? Is it the sea taxi trial? Because that's how politicians back then called the rescuers. They were sea taxis, they were not rescuers, because the assumption was they were just picking up people from the smugglers and bringing them safely to Europe, so acting like a ring of the chain of the smugglers. And that was the terrible charge which led to the seizure of the ship, which have rescued in almost 2 years more than 14,000 people. It's people like you and me, and like everybody who listens. They were not culpable. They had no guilt except trying to seek for a place where they could enjoy a better life. This led to a big uproar in Italian public opinion. The damage was immense because everybody was suspecting that the NGOs were acting in agreement with traffickers. And there was this huge investigation which was politically stimulated. In Italy, the judicial authority is, of course, completely independent. But we had evidence in the case file, which was over 28,000 pages of case file, in which it was the Minister of Interior who ordered the chief of the police to pick up those investigations. So it was a politically driven trial. At the end, we were successful as a team with Francesca Cancellaro, Alessandro Gamberini, and many other lawyers to make the truth coming out. So how you can find the translated decision on many websites, on the Iuventa crew websites, on my firm's website, and the court stated very, very clearly that the investigation were flawed. So there were mistakes, omissions, misrepresentations by police, and the assessed facts, they weren't facts, they were assumptions who were spread over the news with pictures which were wrong in evidence, which were wrong labeled. So they deliberately spread out misleading information to the public, because what was needed here is to convince the public that people who act out of solidarity, they don't really do it for solidarity. They do it for money, for seeking donations from who was involved in those campaigns, and they weren't really looking for upholding fundamental rights. So the court at least ordered, and I'll tell you how we won that trial, because the court finally, and in the very last hearings, ordered to the Italian Maritime Rescue Center to provide all the positioning of the ships, to provide all the recorded calls from the ships in order to check what really happened. And you know what? It came out that the rescue boats, they acted on behalf of the Italian Maritime Rescue Center, or informing immediately the Italian Maritime Rescue Center about the rescue operation that they were undertaking, meaning that if there were a people smuggler, it was the Italian Maritime Rescue Center, because they acted on their behalf, and there was no contact at all. Let me state that again. There was no contact at all, which was proven or even as could be assumed with traffickers. So you know that the phones were seized, the computers were seized, even the personal ones. There was a thorough search. The bridge of the ship was wiretapped, and there was no evidence at all, not one single word, which could be used against the defendants in that trial. So that's why the truth came out, and that's why they were acquitted during the very long and complicated preliminary hearing. And we used that hearing in order to address the public opinion of what's happened, because we have systematic problems. We try to make a strategic litigation here. We have the problem of interpretation and translation rights, which should be granted, which is a prerequisite to any fair trial. And we had those defendants who were not speaking Italian at all, and the prosecution denied translation at all. The court ordered a translation of very few pages, about 900 pages out of 28,000. We tried to raise the constitutional legitimacy, or try to go to Luxembourg with the legislation on migration, asking the court to recognize that the Italian law is not complying with international human rights standards. So we were complaining about the fact that our defendants were not in jail because they were white, and if they would have been colored, black or whatever other color, they would have probably put in jail, as all the other black defendants are always put in, because there is a strong racist prejudice in the Italian criminal justice system as well. So we tried to use this trial to make the public opinion aware of what was happening. We asked for the first time in Italy's judicial history international observers to be allowed into the courtroom, and the court granted authorization. I would like to state that the prosecution was against that initially, but the court said, what are you afraid about? So the justice needs to be a glass house, and this is important. Everybody witnesses what's going on here. So this was just more, I think, than a trial, a case. It was a way to challenge European and Italian immigration policy. And I remember my defendants showing up in court with t-shirts saying like something like less Frontex, more ferries, or abolish the border. And their courage, not only during their rescue operation, but even during the trial, was really inspiring for me.
I see that.
Nicola, regarding also protection of fundamental rights, as we know, one of the greatest guarantees associated with criminal law proceedings is presumption of
I'm
innocence.
sorry. Okay, the last question, because then I need to leave. Sorry for that.
Yes, yes.
The presumption of
This
innocence.
also, yes, yes, we understand, and this also represents one of the greatest challenges in criminal law and proceedings. You've already said that your job is to defend the rights both in and outside the courtrooms. In this sense, which are the greater challenge associated with the criminal defense? Defense before the courts, or defense before the society?
A very interesting question. Thank you for that. I think they go both hand in hand because we can, with the strategic litigation, address the court and address the society about systemic problems. I don't know. Let's think about racial profiling, which is a problem, or targeting of defendants because of the color of their skin. If you ask, if police checks only non-white people, it's likely that the percentage of possible crimes committed by non-whites are discovered in a better way than not the others, because if you check only one part of population of society, it's obvious that you will find only those people being involved in alleged criminal activity. So I had some cases in which I tried to prove that searches and seizures were politically motivated by Italian police. We know the case law from Strasbourg, which I think involved Portugal as well 15 years ago. And the court in Strasbourg ruled that this racial profiling by police is absolutely unlawful. So when you have a case like that in court, you can use same case to make attention raised to that problem, but it goes in many trials. Let's think about the prison conditions. Let's think about, in Italy we still use cages in our courtrooms to keep defendants let's say safe, and I would like to put safe under so really a relative way. Yes, exactly. So it's really a way to treat them in an inhuman, interrogating way, because not even an animal can be held in a cage anymore. So how can you put presumed innocent people? And so you put out these systemic problems, and you bring that to the under the attention of public opinion, even if this costs a lot of energy. But as somebody said, lost causes are the only worth fighting for.
And
Thank you very much.
Nicola, thank you very much for your willingness to share your dense and interesting Italian and international experience. And on that note, we are closing this episode and ask the audience to follow us on our social media and channels. Thank you.
You can also find articles written by Nicola Canestrini on LinkedIn and on his website CanestriniLex. It's been a pleasure.
Yes.
Yes, thanks a lot for